Hello and welcome. Thank you so much for tuning in. Today we're going to be talking about trademarks, and this is something that I get asked quite a bit, and I wanted to do a video to make sure that you understood more about trademarks so that you can understand the importance of them. And so before you apply for a trademark on your own, please watch this video so that you can get a better understanding of what it is that you're looking for, what it is that you want, and so that you're informed whether you purchase from an attorney or whether you attempt to do it on your own. Make sure you're informed, because that's always the key to having a solid process. If you are new here, my name is Taylor Darcy from Think Legal, and I help you create the business of your dreams. So welcome. I'm very excited to have you here, because it means that you are taking the first step in building your brand. If you are curious what that means specifically, feel free to reach out to me in the comments, and I'm more than happy to discuss what building your brand means. And so let's get started. So first of all, let's talk about what a trademark is and what it is not. And then also what a service mark is and what it is not. A trademark is a design, a name, a logo, anything that could uniquely identify your brand, your company. So for instance, the most common broad is a name, if you will. Think Apple. Okay, when you think of Apple, you think of a logo of an apple with the bite taken out of it, particularly a Macintosh. And so that's a non-descriptive, because Apple doesn't describe what it does. It only says it's an apple. So the idea being that's part of the brand, is it's a non-descriptive. Think Coca-Cola, think Pepsi, think these big brands that you're aware of. You're thinking of the brand when you say the word Pepsi. Okay, you might think of the logo as well, but that's not as common as the Pepsi actual name. So there's different things that you can trademark in that respect. You can trademark the name, you can trademark the logo, you can trademark a combination of it. You can trademark the font if you so choose as part of it. So you really have a lot of flexibility in what you can do as far as a trademark. The other thing that you can do is a service mark, and a service mark is almost identical to a trademark, except for it's for a service-based business as opposed to a product. So think of Joe's Plumbing. Okay, there's no product that they're selling. Now you can't necessarily trademark Joe's Plumbing, and we'll talk about more of those reasons why in just a few minutes. But the idea being that a service mark is for a service thing, company. Joe's Plumbing, it delivers a service. It doesn't deliver a product. Now, it might deliver a product if it developed its own product, and you'd want to have that trademarked separately from the service mark. But generally speaking, it's a service mark and a trademark are two different things. And if you're applying for one or the other, you want to consider whether applying for the opposite would be helpful for you as well, because the last thing you want to do is apply for something that and then have to go through the process again if you can avoid it. So if you're at all thinking of, like, say Joe's Plumbing has this special type brand or special design of some epoxy sealant that they use for pipes, okay, and they want to sell that. That's when you would trademark that for that product. Okay, so it'd be Joe's Plumbing, this and for a trademark, and then for their service mark as well. So you're going to have two in that respect. So that's just a basic understanding of what a trademark is, what a service mark is. You have to keep in mind is that it's not good forever. You have to renew it. You have to spend 10 years that you have to renew your trademark, or until you have to renew your trademark, which means that you can, if you abandon it or you don't renew your trademark, then you have to go through the whole process all over again from the beginning to the end. and that can be time consuming and costly. So it's always better if you renew a trademark rather than let it lapse, expire, or abandon. Because otherwise, then you run that risk of somebody else taking it, even though you did all the work for it. For instance, my company, I'm going to be trademarking my company name, and point is that there were actually people that had already trademarked this name, but they abandoned it. They let it go. So I have the option of now taking care of it. So again, good for 10 years. So you want to pay attention to that. You want to make sure you're not letting that lapse. So set it on your calendar, set reminders, make sure you're doing what you got to do to go from there. So a trademark is kind of restricted. You can't claim too much. You have to it has to be based on something related to your business. It can't be something too broad or too vague. It can't claim a simple. It can't be like Nike guitars, right? Because Nike already has the brand for that, and so there's a potential for an issue. Trademark must be used in commerce or plan to be used. So you can file a plan to be used in commerce if you want to. It's usually typically better because then you have to then later apply to show them that you're using it in commerce. So it's always better to start with it that you're already using it in commerce in order for you to enjoy the benefits, so that it's not, you don't have to do the 2 steps to it. So generally when I speak with someone about a trademark, I recommend that they wait till they're using it. Now, it doesn't have to be prevalent in commerce, so don't misunderstand. It just needs to be used in commerce. So there has to be like a notice period where people understand that that's your logo or your name or your brand or that type of thing. It can't be that you're intending it, and you can register that, but then you have to then, once it's in commerce, then show that it's in commerce. So you need to make sure that it's clear what you're doing with that. Let's see. For a trademark, you cannot claim any type of mark that are immoral, deceptive, scandalous, or disparaging, false indication, geographical indications for wines and spirits. So you can't claim it's from France wine, or French wine if it's really not, if it's American. So it needs to be truthful is the point. The trademark or service mark needs to be truthful. It needs to be accurate. It needs to be reflective of the things that you are selling or the service that you're selling, in order to make sure that people are on notice properly. You also cannot use marks of things that you cannot use something that might confuse with something else. Like you couldn't use the mark Coca Cola instead of la would be low, like Coca-Cola. Okay. Because Coca-Cola is going to go, hey, that's too close to my mark. It's not fair. And the USPTO, the U.S. Patent and Trade Office, Trademark Office won't allow you to register it if it's something that could be confused. Now, sometimes they're a little too broad. They give a little bit too much. I've worked on trademarks before where they they wouldn't allow us to register a brand name, even though there wasn't a likelihood of confusion. The problem is the cost that goes with fighting that type of thing is expensive. They said it would. I disagree, but I'm not the one that makes the decision. So it's got to be distinct. The more unique it is, the better. Like Joe's Plumbing, that's why that would never really work, because for the rest of the entire United States, you couldn't have anybody else that has Joe's Plumbing on it. And I mean, that would just be horrific for your brand, right? And the amount of lawsuits and things that are involved with that would just get too costly. So you really want to focus on the uniqueness of your business, the unique factors of your trademark. Don't focus on getting on too much onto once you get one trademark, don't focus too much on the minutia, focus on the brand. And that's really what the purpose of a trademark is for. A trademark is to help establish your brand nationally. There is, some, and this, I want to be very clear on this one. Even if you register your business as an LLC or a corporation at the state level, you do not enjoy national-wide brand protection. That is only at the state level, which means that if you register your LLC in California, someone in Delaware could register an LLC of the same name, or in New York, or wherever. You do not enjoy brand protection at that point. So the whole purpose of being able to do a trademark is to enjoy brand protection throughout the entire United States. And that is the key. Like, that's what you're looking for. You want to be able to, especially if you plan on expanding or just building a brand, you want it to be something that's big, and you want to be able to have it protected no matter whatever state. Now, there are some instances where you could register a trademark within the state, but that's not much better than applying for the LLC in that same state, or the corporation or whatever, because you're just getting statewide protection and you kind of already have that, versus why not just spend the extra money and go national and get your better bang for your buck, nationally speaking, and build that brand right over the national instead of the local state. If you have any questions, please feel free to leave them in the comments below. If you have not yet subscribed, please don't forget to subscribe and hit the bell button so that you get notified when I go live. I do go live every weekday, Monday through Friday, non-holidays, that type of thing, at 11 a.m. And please join me if you're not, and I look forward to meeting with you and helping you build your business. Create your business, because that's what I really love to do. And this is just each day we're going to talk about a different topic. And so feel free to chime in, or whenever you're free or available, or just want to say hi. I'm always looking to help people and to talk with them about their legal needs, especially businesses.